Welcome the parties and participants.
On the day that the trial against President Uhuru Kenyatta was meant to start, parties and participants in the case converged for a status conference at the Hague-based court, and the prosecution sought to explain just why it requested an adjournment to the case. Under a new request, instead of the 3 months they had requested, the prosecution wants an open-ended deferment with no fixed date.
But the request which is now before the court from the prosecution is that the trial should continue to be adjourned without a date being fixed for the opening of the trial until such time as the government of Kenya complies with its treaty obligations under the Statute of Rome.
In other words, are we to understand that the new request for adjournment of the trial pending compliance by government of Kenya with an outstanding request for assistance is intended to entirely replace the earlier request for 3 months adjournment?
In essence, the answer is yes. The difference between the two requests is that the earlier request was limited in time to a period of 3 months. Speaking frankly, the 3-month period was no more than the best rough estimate which we could then come up with, hoping, as we then did, that the investigative steps which we outlined to the court might bear fruit. Those investigative steps have not borne fruit and cannot reasonably now be expected to do so. And so the prosecution is thrown back upon other matters which it did raise in that initial filing. Principally, the submission that the government of Kenya has obstructed this investigation by its non-compliance with requests for assistance.
The prosecution argues that it needs to access Kenyatta's financial records and movement of funds based on claims that he used large amounts of money to fund the post-election violence.
One of the allegations we make against Mr. Kenyatta is that he personally provided very large quantities of money which were funneled down through his intermediaries and messengers and delivered in the form of cash to the perpetrators of the violence. The request for assistance which we made was for Mr. Kenyatta's financial records, because, we suggest, if he did indeed make such financial contributions, there would likely to be records of movement of funds at the relevant time.
The prosecution is not sure whether this would result in evidence which would allow you to proceed to trial on the basis of current charges. Am I correct?
Your Honour is absolutely correct. We do not know what is contained within those financial records. I hope a moment ago explored the two possibilities. One is that Mr. Kenyatta's bank accounts are in a stasis, that nothing's happening, which on the face of it would be highly suggestive of his innocence, at least of his non-involvement in the way we have suggested. Or alternatively, there may be unexplained movement of large amounts of money. We don't know the answer to that because the government of Kenya has prevented us from finding out.
But the Kenyatta defense, led by his lead lawyer, Queen's Counsel Stephen Kay, argued that the prosecution's case was based on falsehoods, largely drawn from unreliable witnesses.
So what has happened then? What has happened was that a narrative was created. A narrative by the prosecution, first of all in its investigation filings, then in the confirmation of charges. A narrative that has been a hope that Mr. Gaynor's clients have clung to, believing that someone who was responsible should be punished. That narrative, however, with all its passion from him, was based upon false evidence.
As President, Mr. Kenyatta has unleashed a diplomatic campaign of startling hostility directed at trying to reduce support for this court in an effort to help him escape trial.
The chamber will hold another status conference on a date to be announced to discuss issues based on Rule 87 on non-compliance of the Rome Statute. Jacky Maribe, Power Breakfast News.